please, my lord and my ladies, I appear on behalf of the appellant with my learned friends Mr. Thorpe and Mr. Westwell, and the court will see that to my right is my learned friend Mr. Warnock of King's Counsel, leading Mr. Spencer on behalf of the respondent. If it pleases the court, may I refer to the appellant throughout as the claimant and the respondent as a defendant, just to make my life, if only mine, a little bit simpler?
Yes, entirely. Content with that. Yes.
My lord, by way of introduction, can I start by setting out the parts of the claimant's case on the appeal that I intend to focus on by way of oral submissions, leaving the remainder to the submissions already made in writing. And to this end, can I invite the court, please, to go to the grounds of appeal, which are in the core bundle at page 15. I did anticipate the court would be doing exactly what I don't manage, which is to run this through the computer only, and so I wasn't tabbing things, but I will hopefully give you the tab number as well, as I see that the court in this respect alone is no further forward than I am in relation to the technology. But my lord, you can see from page 15 the appellant's grounds for appeal, and can I go through those, please? In relation to ground 1, Judge Erdin Law, in finding that Irwin Mitchell did not owe a duty to Mrs. Miller any common law implied contractual duty of care until the 25th of January 2016, I am going to focus in oral submissions entirely on our case relating to there being a common law duty of care rather than an implied retainer, and common law duty of care on the 19th of May 2014 in particular. So ground 1 proceeds orally as a challenge to the judges not having recognised any duty of care was owed by the defendant to the claimant through the legal helpline conversation of the 19th of May 2014. And ground 2 homes in on the content of the duty which the claimant says was owed. Again, in terms of oral submissions, I shall focus only on our case that the defendant was in breach, owed and was in breach of its common law duty on the 19th of May 2014 to advise the claimant promptly to notify low cost, the tour operator, about her accident. So that's the substance of the duty which we say was owed. Ground 3 is pursued, albeit in our respectful submission, the real issue is not so much the proper construction and effect of the excess clause as what are the chances that the insurer would have responded, brackets, had early notification taken place, but the case had not been ready to settle until after low cost had gone into administration. That's the real question for the court. What are the chances?
That is presumably a finding of fact.
One gets to it as a finding of fact, my lady. There are 3 parts to that case which I'll come to in due course, and one of the parts involves assuming against the claimant's case that the matter would have gone all the way to trial, and if it gone all the way to trial, that one then has to consider the merits of the position had it gone to trial, and that's not just an issue of fact, it's an mixed issue of fact and law. And ground 4 I don't propose to make submissions on because that's concerned with the judge's finding below that there was a 0% chance of low cost and policy responding had notification been given sometime after the 19th of May, but our case is focusing today on the 19th of May, and it's common ground that had the defendant informed or advised the claimant of her need promptly to inform low cost about her accident, then low cost would have informed HCC and there would have been no issue in relation to notification.
That's very helpful, but I am going to ask you the difficult question. What does it mean that you're not going to mention orally the other aspects.
My Lord, I don't think I'm making a concession as such, and I don't never welcome making concessions unless I have to. But I am focusing orally to indicate in clear terms to the court that this is the case that I consider to be our
That's your
best
primary
case.
case.
Absolutely.
And the time estimate is 1.5 days, is that right?
No. I'm free next tomorrow, but I'd understood it to be 1 day.
Oh, 1 day. Well,
Perhaps it's not. Perhaps.
all the better.
We'd understood it was 1.5 days, but if we can do it in a day, we'd be delighted.
Well, we had been saying that we thought it probably could be done in a day, so if that's the case, then so be it.
My Lord, I'd certainly anticipated trying to squeeze my submissions in by lunchtime.
Well, you must see how you go.
I'm very grateful.
The court does have it down for a day and a half, so you must not feel constrained to do so. But if it's sensible to do so, then obviously that would be desirable, and particularly now you've cut it down.
My Lord, yes.
Yes.
Trying to home in. So there are really two issues on which I'd like to address the court. One was a common law duty of care owed by the defendant to the claimant on the 19th of May to advise her that she should herself make contact with low cost. And two, if so, what was the chance that HCC, the insurer, would have provided cover or, in any event, funds to settle the case? In relation to the first issue, then, was a duty owed. That engages both grounds 1 and 2. And through ground 1, I propose to address how it is, in our respectful submission, that the defendant owed a legal duty of care to the claimant in relation to the provision of legal advice relating to the limitation period applicable to her claim. The judgment below, as I follow it, leads to a conclusion no duty was owed. I don't know if that's really the judge saying no relevant duty was owed or saying no duty at all was owed.
I think he's saying no relevant duty because your case below was that there was a duty that was commensurate with the kind of duty that would arise under a formal retainer. I certainly, speaking for myself, didn't read his judgment as saying that there was no duty of care at all.
Well, lady, I'm very grateful. What I propose to do in any event is to go through, because it's a crucial stepping stone in the argument that I'm seeking to present to the court. And then via ground 2, I will then seek to persuade this court that the ambit of the duty of care extended to require the defendant to advise the claimant to make contact with the tour operator. And can I just start with the legal test, which I don't think is in any way an issue, but I think I must seek to set out what we say the law is in relation to the court's assessment as to whether a duty of care should be held to exist. If my lord wants to ask a question, looks like one is on the tip of your tongue.
No,
I'm sorry. So can I do that by making clear the claim is based squarely on the principle of assumption of responsibility, which involves two elements, which I'm going to read out in a moment, but I'm going to at the same time just take you to the NRAM against Steele case, which is Authorities Bundle 2, and it's tab 23, and it's page 523 that I'm going to go to in the judgment of Lord Wilson. So that was Authorities 2, tab 23, page 523, please. And if you kindly go to the sidebar paragraph 19, so 523, page 523. Then what is clear from the first sentence of paragraph 19 is that there are two core elements. That the claimant reasonably relies on a representation from the defendant, and that the defendant reasonably foresees or foresaw that the claimant would so rely. I'm not going to read out the remainder of the paragraph, but it's there for the court's attention. And in terms of guidance as to how to determine whether in law, because it is a question of law, such a duty did exist, Can I then invite the court to tab 27 of the same bundle? And this is the Privy Council case JPSPC4. The court can go to page 657, please. And we're in the joint judgment of Lord Hamlin and Lord Burrows.
Sorry, which page?
Page 657, my
Thank you
lady.
very much.
657. We're going to go over to 658. I'll start at para 62. Para 62, first sentence. The test for determining whether responsibility has been assumed by a defendant to a claimant is an objective one. And if you kindly drop down to 63 in the quote from Williams and Natural Life in the judgment of Lord Stain, the touchstone of liability is not the state of mind of the defendant. An objective test means the primary focus must be on things said or done by the defendant, or on his behalf, in dealings with the plaintiff. If you drop down in the same quote, subject to this qualification, the primary focus must be on exchanges, in which term I include statements and conduct, which cross the line between the defendant and the plaintiff. That's pretty clear as to what Lord Stain is inviting the court to focus on. And then if you see right at the bottom of 64, referencing Clark and Linsell, factors which have been of particular relevance in determining whether there's an assumption of responsibility in relation to a task or service undertaken include, and then over the page, the purpose of the task or service and whether it's for the benefit of the claimant, the defendant's knowledge and whether it is or ought to be known the claimant will be relying on the defendant's performance of the task. That's an echo of what we've seen in the NRAM case. And ditto, the reasonableness of the claimant's reliance on the performance of the task is also an echo of that which Lord Wilson set out. And the court has to keep a weather eye, not just on foreseeability that the claimant will rely on the defendant, but also whether there are other factors which would make such an imposition of liability unreasonable or unfair, to which I would add reasonable and fair. But the unreasonable or unfair, we can see this in tab 25, still in Authority Bundle 2, in a case called P&P Property Limited, at page 581, 581. tab 25. We're in the judgment of Lord Justice Patton, and right down towards the bottom, paragraph 76, sidebarred by both legal teams. And can you see at H, but on the basis that the court is deciding whether to treat the defendant as having assumed legal responsibility to the third party non-client for his actions, it would be necessary to balance the foreseeability the defendant will rely on the professional to perform their task in a competent manner against any other factors which would make such an imposition of liability unreasonable or unfair. And since the court has to look at all the circumstances, of course, there may be factors that make it particularly reasonable and fair. It's clear that a duty of care can be owed by a solicitor to a prospective client, in other words, a non-client with whom there is no retainer. And we see that amongst other places, but for these purposes we can go to the judgment from Lady Justice Carr, which then was in the Spire property case, still in Authority 2, tab 28, please. Tab 28. Page 677. The 677's got quite a lot going on in 678 to the top of 679, and in due course I would invite the court, if if I may, to read the entirety of 57 down, even though that's not sidebarred, 57 to 67. Because Lady Justice Carr raises an issue that I don't think actually needs to be determined as a binary issue in the way that it's identified by the parties before her in this litigation, and I'll just come to that in a moment. 57 sets the scene, because 57 sets out the case law well known to this court, that when the solicitor is under a retainer with the client, the solicitor's advisory duty isn't just that which was expressly set out, please advise me on X, but that it covers matters which are, as you can see, reasonably incidental. I'm looking now at the third line of paragraph 57, if the court can see that. The court have that paragraph.
Yes.
And then if you drop down, you'll see a judgment from Mr. Justice Green, as he then was, still in para 57, that it would only be in obvious cases that an extended duty to advise would arise. There needs to be a close and strong nexus between a retainer and a matter upon which it said a professional should have advised. And then at paragraph 59, Lady Justice Carr deals with a situation where there is no retainer. And I'm not going to read out all of that paragraph, but at the bottom of it, we've got a double negative here. But you'll see the fact that information or advice is provided gratuitously negates neither the assumption of responsibility nor the requirement to perform the task so assumed with reasonable skill and care. In other words, you can have a duty of care, pre or post retainer, because there are cases that deal with this, which we're going to look at in a moment. And paragraph 60, emphasising again, judge objectively in context and without the benefit of hindsight, obviously makes sense. And so we're looking at the 19th of May. And again, you see the same sort of principles emerging here by reference to the Williams and Natural Health Foods. If you go over the page, primary focus being on exchanges which cross the line between the solicitor and the claimant, and a fact-sensitive inquiry in each case is necessarily required. Does the court see that? That's the top of 678. And then I'm going to just carry on with this. I'm going to take you to Crossenham, but I'm going to carry on with this now because then you won't have to come back to this case. So Lady Justice Carr identifies cases where in practice this has happened. And the relevant case for our purposes is Crossenham, which she mentions. And it's relevant because this was a case, Crossenham, of a pre-retainer as opposed to the other ones which are post-retainer cases. And Lady Justice Carr pulls out from the judgment of Mr. Justice Kennedy in the Crossenham case, see para 61, but towards the bottom of it, his statement. Do you see? She says, however, the statement of Kennedy J in Crossenham at 106, which I'll come to in a moment, is helpful. Once the solicitor has made the election without qualification or disclaimer to assist the plaintiff as to how he should obtain the funds to pay legal costs, it became the duty of the solicitor to exercise reasonable care and skill in the performance of the limited task he had undertaken to perform. And that's important. And I'll give that the context by going to Crossenham in a moment, but just to stay here, there were then two further issues of law. And the second one, it uses 62.2, whether or not, where there is no retainer and liability rests solely on an assumption of responsibility, the solicitor's duty extends to matters reasonably incidental to the tasks that the solicitor had volunteered to undertake. In other words, employing the reasonably incidental test, which is known to exist in a retainer relationship between solicitor and client, through a case in which there is an assumption of responsibility in relation to X, and whether or not Y, advice in relation to Y, is deemed to be reasonably incidental to it, such that the assumption of responsibility duty extends to it. That's what the issue was, as I understand it, between the parties. And
you didn't resolve it.
As you didn't resolve it, lady, that's why I say it's, so that's been left there. But I'm quite content to say what our position is in relation to that. I consider it somewhat artificial if we were to propose to this court that the sort of mechanistically the route through is to say I can establish an assumption of responsibility in relation to X, and all I need to do is to satisfy these form of words called reasonably incidental, as if it was some absolutely rigid legal test, because it isn't. And we would accept that the court ultimately has to determine whether or not the duty which I've set out already, that we contend for, which is a duty upon the solicitor defendant in this case, to advise the claimant of the need for her promptly to notify the tour operator, so it could notify its insurer, whether or not that exists. And we do not shy from that by reference to the more circuitous route of saying all you need to do is establish this duty over here and then apply a rigid test called reasonably incidental. What we do say, however, is when looking at whether or not there is an assumption of responsibility, working out whether or not there was an assumption of responsibility in relation to something else, and whether or not these are part of a bigger picture and or reasonably incidental is critical. But it's not, I don't take it from there to being a sort of different test. I totally accept and embrace that we have to ultimately persuade this court that there was an assumption of responsibility in relation to the duty that we contend for. I hope that's sufficiently clear. If your lordship has any issues arising out of that, or whether I hope to have made the position clear. So we think that would be.
So you're not relying on the reasonably incidental concept to found the duty, but you're still saying it's critical.
Yes, it's highly relevant, critical. I mean, call it how one will. The point is, it's what lies beneath, my lady. The courts come up, and this is what the courts function, but the courts come up with forms of words. And one has to remember, we're just dealing with a common law duty of care. I'm not going to go away from that by saying there's all this case law that says assumption of responsibility involves the following, but I don't need to really do any of that. I just need to go assumption of responsibility here and then take a hard right, and then end up at my destination on the basis that it's reasonably incidental. But I do say that what the court is trying to do when it emphasises how duties can extend beyond that which is expressed is really important and applies here. So I don't elevate it to a legal test, that's all I need to get through. I recognise the legal test as assumption of responsibility, but this is part of, you can describe it as the factual matrix, and I do. It's a really important part of the factual matrix in this case. And
what this all boils down to is that you are accepting the difficulty for your case, that there was at no stage any expression by the solicitors of any responsibility to Mrs. Miller that in relation to notification of the tour operator or anything of that kind.
Apart from the of that kind, my lady, I would be minded to say yes, but not of that kind. Of that kind, no. But in relation to us, absolutely, my lady. We wouldn't be here if there was a representation that was made that was inaccurate. we wouldn't be in court today.
No.
And so that's what the court is grappling with. And Lady Justice Carr, this is an important case in that one can see the issues that arise for her. I hope I've made clear how we propose to address the issue, which I consider to be the only sort of accurate way of approaching it, which is head on, but with a completely, more than a weather eye. It's a hugely important part to understand. That's why case law developed this principle of reasonably incidental in the first place, albeit in relation to the retainer relationship, because the courts seek to reflect a reality rather than trammel itself by reference only to that which was an express representation. And an example of this comes in the Crosnan case, which has been referenced and essentially I would describe it as approved to keep the key reasoning of Mr. Justice Kennedy by the Court of Appeal in the Spire property case at paragraph 61 that I've just taken you to. So can I now go please to the Crosnan case briefly? It's not that I'm going to get home because there is one High Court case that was decided a long time ago. We're ultimately, of course, concerned with simply the facts of this case, but it's instructive to have a look at it. And it's Authority Bundle 1.
lady.
Tab, it is, my lady. I'm very grateful. I think I've got tabs actually for quite a few things more than I think for my own benefit. I thought they were going to be, but that for the courts as well. And it starts at page 165. And if you just go kindly to the head note, so left-hand column at the top. The plaintiff was involved in an accident as a driver of a car, received a summons for reckless driving. He consulted M, a partner in a defendant firm of solicitors. Having decided the plaintiff was not entitled to legal aid, M advised the plaintiff should either defend himself or instruct the defendants, in which event he'd have to pay £50 on account of costs. The plaintiff took the former option, and the defendant was never instructed. M failed to inform the plaintiff that his insurance company would arrange and pay for his legal representation. And in that regard, they were careless, held careless, you see, in the head note. So that is liability on the assumption of responsibility basis for what could be described as an omission. But if you go then to page 168, well, if you go to 167, you'll see the lead up to it, that we're definitely in the world of assumption responsibility. See the sidebarred section on the left-hand side. And then over the page at 168, at the top, in the present case in a business setting across the office desk, Mr. McChrystal, that's the defendant solicitor referred to as M, did, as I find, hold himself out as a person qualified to assist the plaintiff as to how he could obtain funds to pay legal costs. So he advised, do it yourself or pay me. That's all he said. But that was understood by the court essentially as a representation to assist the plaintiff as to how he could obtain funds to pay legal costs. And he need not have done so, but he chose to do so without any qualification or disclaimer. Does the court see? I'm still at page 168. Top, left-hand column at the top. The lady should see it. So it's that sentence, he need not have done so, but he chose to do so without any qualification or disclaimer. Once he made that election, it became, in my judgment, the duty of Mr. McChrystal to exercise reasonable skill and care in the performance of the limited task he had undertaken to perform. And that's the passage which is approved expressly by Lady Justice Carr. On this occasion, he failed in that duty because he failed to advise the plaintiff of a source of funds, which he, as a competent solicitor undertaking road traffic cases in the magistrate court, and often this particular type of advice, ought to have been and was in fact aware, namely the plaintiff's own insurers. I'm happy to read out. My learned friend has sidebarred the next paragraph. He sidebarred the right-hand side. So that I may let my learned friend develop, but you see the passage on the right-hand side in the statement of claim. Plaintiff alleges that he's sidebarred, and the judge refers to this in the judgment. That was dropped as I follow because it's completely unnecessary for the claim that succeeded. Because the claim, this claim, there being a duty of care and a breach, automatically involves prompt notification to the insurer. So no issue then arises in relation to notification. That is the way in which the court analysed what could otherwise be seen as, well, I only advise you can use me or do it yourself. That's all I said. There's nothing more. I never held myself out. I never made a representation in relation to your insurance position, etc.
It's interesting, though, that Mr. Justice Kennedy decided in terms that it wasn't the duty of the solicitor, despite having assumed responsibility in relation to costs, to check that the plaintiff had complied with his duty under his insurance policy to notify his insurers.
Yeah, well, what happened is that was abandoned, as we can see. I think the lady's looking at the right-hand column of 168.
I'm looking at the last line. Whether in discharge of his contractual obligations it would have been his duty to make that check at a later stage, it's unnecessary for me to say. Suffice it to say, I am satisfied that it was not his duty to do so at the earlier stage.
Well, lady, yes, that's because the focus in this case, the Crossan case, was exactly as set out, that it was in relation assisting as to how he could obtain funds to pay legal costs. And so the content married with the duty. And so it does, we say, in relation to our case. Why each case is inevitably fact sensitive. So this is why I'm not going to try to prop my case up by reference to the facts of other cases. So because this court simply has to address, as Lady Justice Carr set out so carefully, the very particular facts in this case and make its assessment. What it's doing is it's an active example of how it is that there are two ways to construe one piece of conduct. And that's ultimately what this court has got to decide, which way to go in relation to that. You can construe that piece of conduct as absolutely limited to that which was expressed, no more. No more assumption of responsibility or otherwise, depending on the facts.
It's quite interesting, though, that there's a duty of care in that case to explore with the putative client, the person that you're advising, his own insurance as a source of the legal funds, which means some contact between him and his insurers, obviously, and an assumption that he is in. It doesn't extend so far as to say, and by the way, you might make sure that you are insured, because if you don't tell your insurers straight away, then you won't have that as a source of your legal funds.
Well, I think on the facts of that case, page 167, what happens is it's above the blue sidebar. Because of his financial straits, the plaintiff chose the former course. If the solicitor discharged his duty to exercise reasonable care, the insurers would have been alerted to the issue of the summons. To Ladyship C,
Yeah.
and they would have arranged for representation. I just don't think it was an issue that arose because the breach directly led to notification. And so what the claimant was arguing was essentially, if I'm wrong in relation to all that I've said already, how am I going to establish the duty of notification of the insurer? It didn't make any sense. That's how I've understood this case, my lady. But he won on, I think it's won on his primary case, and that necessarily involved notification, so the issue simply didn't arise. And all Mr. Justice Kennedy was doing was saying, if I'm wrong in relation to the former, then the claimant doesn't get home. So my lady, my lord and my ladies, can I now go to ground one? The claimant's case is that the defendant clearly owed legal duty to the claimant during the course of the 19th of May telephone call, taking into account the following, and I'm here homing in on the limitation issue. First of all, the claimant phoned a legal helpline. Secondly, Ms. Strutt accepted that the legal helpline provided general preliminary advice. And here I'm going to be going on a number of occasions to the judgment below. And so can I invite the court to bring up the core bundle, please? And the tab 8 of the core bundle, we're at page 122, paragraph 85. That's page 122, tab 8 of the core bundle. And you can see para 85 says the legal helpline provided general preliminary advice. And then if you then kindly go over the page 123, paragraph 87, she described the process when an operator answered the call. They would introduce themselves by name and explain the scope of the legal helpline was limited to providing general preliminary legal advice. And Ms. Strutt saw herself, see paragraph 90, first sentence, said she saw herself as a legal advisor when working on the helpline. further, if you kindly go to paragraph 94, it's just over a couple of pages. The legal advisor expressly represented to the caller, here the claimant, that they would be providing general preliminary legal advice. See para 94, second sentence, or I start at the beginning. The advice that someone like Mrs. Miller would get would of course be tailored to suit their needs. When an operator answered the call via the helpline, they would introduce themselves by name and explain that the scope of the helpline was limited to providing general preliminary legal advice. That's a representation to that effect. And as the judge found here, paragraph 121 at page 140, so page 140 please, sorry for the jumping around. But if you are between the hole punches, just after the learned judge says the relationship between them was not akin to a contractual relationship, so your lordship and ladyship see that, he continues, Mrs. Miller was certainly entitled to rely on such advice as she was given. And furthermore, if you then go back to page 119, 119, paragraph 77, I'm going to make the submission, then I'm going to go through the paragraph if I may. So I'm going to take you in a moment to page 119, paragraph 77. And the submission which I'm making is that the defendant well understood that any legal advice given would be relied on by the customer. And you'll see that paragraph 77 says the tick list at the end of the pro forma makes it clear, if it was not otherwise clear, that the provision of generic preliminary legal advice contemplated was not just to explain why the questions were being asked, it was at least equally a way of engaging with the customer. That is, as I take it, giving the customer for free something which felt as if it was of value. Counsel,
Where are you reading from?
My lady, page 119.
Page 119, sorry.
Yeah, sorry, yes,
paragraph
yes.
119.
Judgment, para 77. 77. What I'll do, if I may, is I'll just go through this again. So, para 77, or perhaps having read it in court, can I just invite the court just to read 77, please? It is absolutely inherent in our respectful submission in that paragraph that the judge was finding that the defendant well understood that it was giving the claimant a benefit, something of value, inevitably therefore giving the claimant advice that she would rely on. The whole paragraph makes absolutely no sense unless you so find. That's all. That's what it's all about. Engaging with the customer, giving the customer for free something which felt it was of value, namely general preliminary legal advice.
Well, it's called a legal helpline. So
It's
what
called
you'd expect to get is legal help.
It's called a legal helpline. So it's a sort of, I've got enough, all those sort of, that's the factual matrix I'm trying to just go through, rehearse. Furthermore, Ms. Strutt would expect advice to be given on limitation. Now this is page 124, judgment paragraph 92. 92, please. So if you drop down right down to the bottom of 3 lines up from the bottom of 92, she would expect advice to be given on limitation, but it would not be definitive. Does the court see that?
Oh, sorry, page 92 is it?
Yeah, well, no, I seem to be. I'm going to try to be as clear as possible because we. Page 124.
Yes, page
92.
Thank you.
And 3 lines up from the bottom. This is Miss Strutt, would expect advice to be given on limitation, but it would not be definitive. And then if you just read the next bit, it's the next point I'm making, which was there was no disclaimer. that the advisors were not trained to say that they were not giving advice, nor trained to say that the caller could not rely on any advice given on the call. And then on the facts of this case, Miss Halliwell, who was the operator of the call, did give the claimant advice that there was a 3-year limitation period. Now this is page 97, paragraph 20. And 3 lines up from the bottom, but you can pick it up slightly higher up with under the heading advice. She records, Mrs. Miller was advised of the scope of the legal helpline was given some account of personal injury in terms of duty, breach and causation, and that there was a 3-year limitation period. And the reference, if you want to look at the actual document, but I don't think it's necessary to take you to it, is Supplementary Bundle, tab 18, page 182. If the court's interested, then I'll show you where to find it. It's not immediately easy. So, starting at 166, this is the pro forma document that the operator of the legal helpline would use. The court sees that. If you go over the page, you can then see that it's been filled in 2 ways, both with typescript and also by hand. And my understanding is that the by hand was post the 19th of May. And so reference should only be made to that which is in typescript for these purposes. And if you then kindly go to page 182, you'll see towards the top you get all that was typed in, and if you drop down between the hole punches, it says advice, scope of LHL, personal injury, duty, breach, causation, 3-year. Clearly that's limitation period. Limitation period in English it may be, or it says English position after, so limitation period, English position. If your lordship wishes me to carry on, I was still...
So the advice given was scope of LHL. What does that mean?
Legal helpline.
Yes,
Scope
that's
of
exactly. Thank you, my lady. Scope of legal helpline.
3-year limitation period expiry period.
Yes, expiry, but it's the 3-year limitation, but it's as found by the judge. Para 20, but you're right, probably expiry.
Injury greater than 4 weeks.
I think that's because views are taken as to the benefit for the solicitor of engaging with the client if the claim is for an injury which has not lasted for 4 weeks. Proportionality issues in terms of recovery of costs, etc. There's reference to that in one of the witness statements.
So you say that the defendant sets up a legal advice helpline and gives legal advice expressly without any caveats as to whether or not it can be relied upon, and so there is the plainest assumption of responsibility.
Oh, in relation to the limitation period, it's, I would say, fairly obvious, but important to set it up in this way because of it's a stepping stone in my case. But absolutely, it could hardly be more obvious. Imagine they'd said 6 years.
Yes, quite.
Quite, but the scope of
Oh, yes.
the advice given is much wider than that, including
Yes.
in relation to duty, breach, and causation.
My lord, yes. It's part of what I'm describing as the factual matrix when coming, which is my ground 2 submission, to why in our respectful submission this includes or embraces the duty to advise the claimant to notify the tour operator so it can notify its insurer promptly. The insurance will be triggered or cover will be given. Before I just before I get yes, my lord.
Just to understand it a bit more.
Yes, my lord.
Plainly, any notification provision in any insurance policy, it is unlikely to be of the sort of order of a day or 2 days or a week. So at this stage, 19th of May, why would that be in the mind of a legal helpline advisor?
Oh, my lord, I'm a complete answer to all of this, but forgive me, I'm slightly reluctant to just leap into my ground 2. I'm almost at ground 2.
Okay.
Is that all right, my lord?
Yes, you must take your own course.
Well, I really want to answer the question, but I will literally just be doing the whole of ground 2. That is exactly our case. It's rather respectfully the other way round. It's precisely because when someone comes early that we're within time to notify, and it's a crucial step to be taken then. Anyway, can I seek to develop?
Well, either do it or don't.
Yes,
Up
you're
to you.
absolutely
So
right.
they ring the helpline 6 months before the end of the limitation period, no duty of care.
My lady, I think that's its own question because on a separate set of facts in which there may be terrible problems on causation because if one's dealing with it 2 years and 6 months later. But if I can put it this way, it is a fortiori in a case in which there won't be a difficulty if the step is taken. Indeed, in other words, it will be a purposeful step to be taken. So I would probably land on there is a duty even at 2.5 years. But this is a fortiori that. It's that way round rather than the other way round. I was just going to complete the ground 1 submission by making this submission that there's no merit for the avoidance of any doubt in our respectful submission in a distinction being drawn between general legal advice at a high level and legal advice. From the claimant's perspective, she was being advised that she had 3 years in which to bring her claim. And advising that the limitation period is 3 years is for these purposes the same as advising the claimant that the limitation period for her claim is 3 years. There's no material distinction. The judge understood this. If you kindly go to page 119. Paragraph 76. Last part of para 76, 4 lines up from the bottom. In cross-examination, he said that advice would not be given unless to help the person calling, but he recognised that whatever generic legal advice any operator would give would be received by the caller and understood and applied in the context of their claim. So it doesn't do for someone to say, well, it's at a high level. It's not. It's real advice to a customer. It's anyway the position that the obligation to advise the claimant in relation to contacting a tour operator, that could be described as a general point, because it is a general point for personal injury litigation, which I'm going to come to, not just for accidents abroad. It could be headed general legal advice. It makes no difference because it's legal advice to the claimant. Well, can I then turn to ground 2? So the question in relation to ground 2 is not so much a freestanding question, whether any duty was owed by the claimant to the defendant, to the claimant in relation to the helpline conversation. Rather, the question is as to the ambit of the duty of care, and specifically as to whether it extended to owing the claimant a duty to advise her to make contact herself with low cost. And the claimant's essential case is that the duty to advise her to make contact with low cost was part and parcel of that which the defendant chose to advise the claimant on when the defendant advised the claimant in relation to limitation. So the advice on limitation was an incomplete and misleading representation for the claimant that in effect she was safe to delay taking further steps in the prosecution of her claim for up to 3 years from the date of her injury.
That's because the risk that the proposed defendant to any claim would become insolvent.
Not specifically, my lord. No. The reality in personal injury litigation is as follows: we do not sue uninsured defendants. Ignore public authorities, talking about private defendants. And I've had 30 years at the personal injury bar, and I can think of an individual that I've sued whose father was extremely wealthy. I can think of a case in which we discovered the defendant was uninsured and the case went to pot. All road traffic litigation is insured because the MIB sits as the insurer of last resort. So road traffic is, there is an insurer or the MIB out there. And all other litigation doesn't really matter the size of a company. It is as rare as hen's teeth for claimants to be retained to sue uninsured defendants. This is a case with a value before the personal injury claim, not the professional negligence, has to take into account whatever reductions need to be factored in for loss of chance. The claim itself, for a woman of, I think she's in her 50s, who sustains a below knee amputation, that sort of 1.5 to 2 million sort of flavour normally is because they get a property, my lady. Swift and Carpenter, the case on accommodation is
Special
a below
damages
knee.
might bring you up. The general damages would be.
Oh, general
much lower
damages
than that.
would not be at that level, my lady, but you
And it very, very fact specific, depending on the specifics of the case, whether you needed to buy a new property, what level of prosthesis, and so on and so forth.
exactly, my lady, absolutely. I'm not. Cases, we also know this, cases vary in value and we sometimes discover whatever, but they have every case has a value and they just do have a value at that sort of level. It's how the figures tend to add up in a case like this. And it's not a question of what's the real risk of the defendant becoming uninsured, impecunious, and going into this company into administration. It's that this is how personal injury works, and that's why when we see it in the pre-action protocol, we see it there as a generic point, a point of application for the personal injury pre-action protocol, not because the guidance is being produced because there's such a deep skepticism that the state of play in our country is such that anyone or anything is about to go bust, but because we go against insurers. We recover. The claimant's legal team only recover their costs, as we know, it's all CFA work, from the defence. And you don't go seeking £1.5 to £2 million plus your cost bill from a defendant with all of the angst and excitement that would then ensue in relation to the enforcement against the defendant, corporate body or otherwise. It's not how we litigate in personal injury at all. So this is, it's not the impecunious point, it's the make sure there's an insurer point, and it's really important and well understood, as I'm going to seek to show, well understood, not just not just generally, but by the defendant in particular in this case, to be really important. And the representation which has been made once the defendant chooses to advise in relation to limitation is in this sense akin to the Crossan case, the working example, because what the defendant has done is it's opened the door to making a representation relax. You've got 3 years, and we see the ensuing conduct. This is not to be judged. This duty of care is not judged with hindsight, but we see the way in which the claimant delayed in returning to the phone calls of the defendant's solicitor, which is exactly of a piece with the state of play, because she'd been advised it's 3 years. And our case is put in short order here, but in pithy form in the skeleton argument. If you can just go back to the core bundle to pages 43 to 44, paragraph 94.
It's interesting, isn't it? Because no doubt it would be said that somebody operating a legal advice helpline who didn't tell the claimant that the limitation period was 3 years was professionally negligent, because that would be an absolute must. But now you're saying if you do actually do your duty and say that it's a 3 year limitation period, you then take on the responsibility also of saying, by the way, you ought to notify the insurance company.
Well, my lady, I would almost see it the other way around in an a fortiori context again, because if the court is saying it's an absolute must, if you omit to advise in relation to limitation period, I'd say a fortiori, because that's 3 years away, a fortiori to take this step. So that's a case I'm happy to embrace, but I've rather operated the other way round on the basis of this is what has happened. Put a different way, if it wasn't a legal helpline and it was just a point of contact and the claimant was invited simply to give an operator details, this is my name, my age, this is what I say has happened to me, and there was absolutely no advice given. It was like, thank you for that, I'm going to pass it on. This is an efficient system we've got going where you speak to me, I'm unqualified, I'll just collect your data and then I'll pass it on. That is a completely different case, and all I'm seeking to do is to show that it's a completely different case, and that, as your ladyship says, we are dealing with a legal helpline in which whether because they needed to or they did, limitation advice was, or on that a different way of analysing it, should have been given. And we're now looking at the effect or scope of that, my lady. So I was just taking the court to paragraph 94 on page 43 of the core bundle. So it's tab 3, page 43. In which we set out, instead of advising Mrs. Miller to inform Locos about the occurrence of her accident, Irwin Mitchell simply advised her about the elements of her course of action and that the limitation period was 3 years. Such advice without more implied that there was nothing Mrs. Miller needed to do promptly in order to protect her position. And can I then take you into the supplemental bundle, please? Tab 50. And you're in the transcript, and we're going to the evidence of Miss Strutt. Page 316, please.
Sorry, 300 and...
316, my lady. Page 316. Bundle issues, my lord. And we're down at G. Question, and also left with the understanding that the position under English law was that she had 3 years from the date of the accident to bring a claim. Yes, So nothing to make her aware that there might be something that she needed to do urgently. Answer, the practice would take, we would expect the practice area would take it from there. We wouldn't have ever expected the advisor to do anything over and above with what Victoria Halliwell did. But so far as what Victoria Halliwell did, nothing for Mrs. Miller to appreciate that there might things she needed to do urgently. No.
The insurance, though, presumably is on a claim basis.
I haven't checked.
It is. No, it's on an instant basis. I checked it. It's incident within the period, not notification of a claim.
And one of the problems here is that if she'd rung up the helpline a few days before the end of the limitation period, the solicitors on the other end of the call, they've no idea what the insurance position is, defense insurance position, and you may well assume that a defendant who is liable for up to 3 years or limitation period only expires will have insurance which covers them for claims made at any point during that 3-year period. You just no idea.
My lord, I'm not sure that we can respectfully accept that, and not least based, I think, on the finding. I'm just going to have to find it of the judge, which I'll.
Trouble is that insurance policies differ. What was unusual about this one was it had 2 exclusion clauses. It didn't just oblige the assured to notify when a formal claim was made against it, which is what you see in quite a lot of these policies. There was also a sub-clause which said you've got to notify of the incident as soon as you know it. And the irony in this case, sadly for Mrs. Miller, is that the insurance company took the point, was able to take the point, because the local representative notified the tour company which sat on its hands, which she had no knowledge of or any influence over, because the manager of the hotel had told them. And therefore they were able to trigger the first of the 2 exclusions, because the second one didn't apply. The company very responsibly went straight to the insurers as soon as Irwin Mitchell sent them the letter before claim. So if it had been a policy which simply had that type of exclusion in it, she'd have been all right. It was because it had that extra exclusion that said you've got to notify promptly after you know of the incident.
Well, yes, but it's that which was well understood to be ordinary. If you go to page 141 of the core bundle, lady, sorry. I'm in the judgment. Paragraph 126.
Yeah.
I would accept that as part of their general legal knowledge, the defendant would have been fully aware that insurance policies against claims such as that of Mrs. Miller would often contain provisions which allow the insurer to decline to indemnify if the underlying incident were not promptly notified.
But how does the claimant notifying low cost affect that?
Because the claimant notifying low cost will then contact his insurer. Low cost wasn't notified until much later. That was the problem.
They can only be in breach of the fall foul of the notification provision if they don't notify when they're told, when they know about it.
Precisely.
So if you don't tell low cost,
Precisely.
if you don't tell them, there is no obligation to notify, unless they already know, in which case they already had an obligation to notify.
Exactly.
So I'm not really sure why notifying low cost is a necessary thing here, because once you notify them, they have an obligation to notify the insurer.
My lord, it's part of the findings of the court. If they've been notified had there been no obligation to notify them until later, but there was after the 19th of May 2014, but before 2016, that the learned judge says there was 0% chance, I think he says, that the insurer HCC would have provided cover because it would have been late notification. That's the issue we're dealing with.
But isn't that again, the point is that's against the context of it being understood that low cost in fact did know of the accident very shortly after it occurred.
No, they didn't know the accident. There's a finding, I have to find it, but there's a finding to that effect. Low cost did not know about the accident. Its intermediary wrote an email on the 15th of May, the day after the accident, to the hotel saying provide us with a full report.
If they didn't know, and that can't be right with respect, and I know it's not right because it was accepted by their own legal team in response to the letter before action that they did know and that they had carried out some preliminary investigations. The insurers could not have repudiated liability on the basis that the intermediary knew, but the insured did not. They had to know.
That's exactly how the case is proceeded, my lady. I just seek to find the finding for you. Exactly how it proceeded, Command 7.
If low cost didn't know, then they had nothing that they could notify, and therefore the insurers wouldn't have been able to get off the hook.
They were able to get off the hook, and that's exactly how the judge found it.
That sounds like a very onerous insurance
Completely
policy.
right.
If you are
It doesn't.
in breach of a notification provision about something you know,
Exactly. They didn't.
that would be
They
pretty.
didn't know.
If
Are
it
you
helps
saying-
the court, the insurers' solicitors took the point, it's in supplemental bundle at page 217, where they accepted that low cost were formally notified of the incident centrally by email on the 15th of May 2014.
It's paragraph 52A on page 34 of the judgment. It couldn't be clearer.
Page 34 of the judgment.
Page 34 of the judgment, paragraph 52A. HCC wrote to low cost declining to
Sorry, no,
afford
the
it
judgment
with
starts at
indemnity.
page 87. Where's your ladyship?
Oh, sorry.
Page 34.
Sorry, that's your skeleton argument. That's your replacement skeleton argument I've just quoted.
Yes, if one wants the source document, and this wasn't contentious below, nobody disputed below that low
The
cost.
page was.
It's page 217 of the supplemental bundle. Lexis Law, who'd been appointed by the insurers to represent HTC, to represent low cost, set out the position.
Yeah, that's the document I had in mind.
Yes, because obviously if they hadn't been told, we wouldn't all be here.
No.
But then the whole claim is you should have told low cost something they already knew,
Yes.
Yes.
which
Well,
doesn't bode well for causation element.
so your lordship will see it's the point we make in our skeleton argument.
So I saw it, and I think we've all been aware of that, which is why we've been interested to hear how it's put.
Paragraph 15 of the judgment at page 95 of the core bundle deals with the issue that I was just referring to, which is the contact that was made by the intermediary on the 15th of May,
Yeah.
inviting a full report from the hotel, and there is no evidence that the hotelier ever did send a report. It's the bottom of paragraph 15.
To the intermediary.
To anyone to go off to the defendant, the tour operator.
No, but that's not a finding by the judge that the tour operator didn't know. I'm sorry to press you on this,
No,
but
my lady.
I'm a little bit surprised that you should be making that submission in the light of what's in your skeleton argument on this appeal.
Well, can you just forgive me, my lady? I was stuck on the page numbering when you made a reference to what was in our skeleton argument.
Page 34, paragraph 52A, which is a reference to the document that we were shown.
Yes, that's what was put. That's not what happened. That's what was put at that time. That's all. Unfortunately, having considered a cover position, HCC wrote saying this, but it's not how it all transpired. I've just got to find you the part of the judgment.
Well, before we go there, can you just help us with page tab 43 in the supplemental bundle to page 217? And this seems to be low cost holidays liability insurers.
Yes, that's a letter from Plexus, which in one regard we say is simply a self-serving letter in which they say, I see what's set down at the bottom of that, but they also say the point would have been taken in relation to the excess. Well, that's the insurer saying would have taken the point.
But Irwin Mitchell got advice from counsel as to whether or not there was any possibility that the insurers were wrong in declining cover.
That's when late notification took place, Molly. That's the whole point. That's what the judge
Yes, but if
addressed.
But the reason it's late notification is because they knew on the 15th of May.
Exactly.
If they were not told, if they never knew, they couldn't have had late notification. And that's where your case seems to me seems to be rather bizarre, because you're saying that there was a breach for not notifying low cost because you needed to notify them so that they could notify. But if they don't know, they can't notify.
Are you maintaining that the policy required notification immediately after the incident, whether or not the tour operator was aware?
Well, yes, that's the effect of it, and that's why notification became a problem later, and the judge so found.
Is there a finding that the judge actually interpreted the clause that way?
I'm just trying to. No, I don't. Well, lady, page 150 of the core bundle, paragraph 141. Had low cost been notified immediately following the initial call with Mrs. Miller, I accept Mr. Mears' evidence, which was plausible and supported by the documentation, in particular documentation relating to the notification of claims and instance, that on behalf of low cost he would promptly have notified HCC.
Well, that's because, and I read it, the judge accepts that if Mrs. Miller herself had notified them directly, they'd have woken up.
The same thing would have happened, exactly.
They'd have woken up, but
Exactly.
in fact they knew from a different source and didn't wake up.
Whether they're held by virtue of an intermediary knowing that they didn't or not, the effect is real and well understood. See that passage which I've already just taken the court to, I think it's paragraph 126 of the judgment. That is a clear finding if you go back to page 141. I would accept that as part of their general legal knowledge, the defendant would have been fully aware that insurance policies against claims such as that of Mrs. Miller would often contain provisions which allow the insurer to decline to indemnify if the underlying incident were not promptly notified. And he makes findings that had the advice been given to Mrs. Miller, then it would have achieved the desired and fully understood effect, namely that HCC would provide coverage, that because she wasn't so advised, they didn't. And it became a 0% chance from 100% chance per the learned judge. So that's why we end up, if you read 141 through to 144, so we're page 150 to 151.
Okay. What I don't see is any. It appears from the supplementary bundle that the Plexus actually declined cover in part, at least, or on the basis that there had been notification in 2014 to low cost. They didn't decline it on a different basis, so they weren't, for example, saying it doesn't matter whether there was notification in 2014 because because the policy doesn't depend on knowledge. They weren't saying that. They actually declined cover on the basis that low cost already knew about it in 2014. That's the basis on which they proceeded. And I can't see anything haven't seen anything in the judgment that addresses that.
My lady, in one sense, my response respectfully is as follows. It's not about the technical basis upon which a problem can arise between a defendant, as in the real defendant, not Irwin Mitchell, a defendant and an insurer. It's about a recognition in the marketplace that prompt notification of a defendant should inspire it to make contact with its insurer and thereby avoid just these points. So it does not matter whether plexus choose to say later on, this is our basis or not. That's not the point. That's delving deep within. But the point is a general point which applies in personal litigation, which is why it's in the pre-action protocol, which is why we're going to see the terms of the letter of claimant, which I'll come to in due course.
With respect, is that right? Because that assumes that there's a general assumption in the marketplace that insurers will decline cover in the event that something is notified well after it happening, even if the insured did not know.
My lady,
And
can I?
promptly know.
Sorry, my lady.
That's why this is relevant.
I don't put it in the terms will do this and will do that. That's not how it needs to be put. It has been put and it has been found by the judge. Forgive me, but I'm going to return to page 141, paragraph 126, and just invite the court for a moment to just put to one side its detailed insurance law analysis, and just reflect on the case which is found on the facts as found by the judge. Para 126, my lady. I would accept that as part of their general legal knowledge, the defendant would have been fully aware. So this is the position, my lady. This is the position. That insurance policies against claims such as that of Mrs. Miller would often contain provisions which allow the insurer to decline to indemnify if the underlying incident were not promptly notified.
And this one did. But you can't notify something of which you're unaware.
My lady, it may be that the issue is what I might end up calling double notification, because you've got the word notifying being used twice. You notify the defendant as in the underlying defendant, and I'll put on the tour operator, it's easier. You notify the tour operator notifies the insurer, and at all stages I've sought to make clear that the assumption of responsibility that I'm promoting to this court is based upon the need of the defendant to advise the claimant to notify, not such a technical word, but make contact with, might be more appropriate.
Alert.
Thank you, Molly. To alert the tour operator so that the tour operator is thereby in a position to notify its insurer. So it may be that we've become, there's been some, sorry, Molly.
I can entirely see that when you make a claim, you send your letter of claim under the pre-action protocol. It's very important to say you must immediately notify your insurers. Because at that point, you put the claim on record, they're notified of the claim, they must notify their insurers. Now, at that point, they know. If they knew about the incident earlier, then they're obliged to notify it to maintain cover. But if they knew about it, you didn't need to tell them. So at the moment, I'm not really understanding the content.
You do, my lord, because what you are doing is you are thereby encouraging or promoting the tour operator, I'm going to call them that so we don't get confused with defendant, the tour operator, to notify its insurer. It's exactly what the judge has found.
I suppose the answer, or one potential answer, is that you don't know whether they know from another source. In fact, in this case, they did know from another source, but you don't know that as the person who's fallen down and had the unfortunate injury. and therefore, belt and braces, you would normally expect the source of the knowledge to come from the person who's been injured, and therefore that's where there's a duty, you would say.
My lady, yes, it's the position in a travel case. The sort of interesting feature of a travel case is that the tour operator doesn't own the hotel, doesn't run the hotel. So it's if you like, it's not on my land. So it's not quite the same as an employer, and you see them fall over in your premises, and you set up your RID or accident report form or something of that nature. Instead, what you've got is an accident which occurs abroad in a hotel, which is in a contractual relationship, often with an intermediary between them and the tour operator. And so you've got channels of communication issues, and what you know is that which the judge has found, and it's paragraph 126. Forgive me for going back to this, why I did not see this as a live issue in this case at all, because this is exactly the basis upon which the case has proceeded. It doesn't matter what your technical position is, you don't know. What you know is, because you're not going to know, my learned friend takes the point about res alios, etc., that we're not privy to their insurance contract. So that's the whole point. It's not about let's look at the insurance contract and see exactly what it does and doesn't do. The point is, it was general legal knowledge in this marketplace. See para 126. That this is a step which is a very good step to take, because otherwise you face there being no insurance coverage. I would normally colloquially describe that as no insurer on the hook, but no insurance coverage.
63, page 114, just about that email from Phillips. Just have a look at that last.
Yes, and my learner junior has kindly found the references in the back of my mind. If you just kindly go to page 114 of the core bundle, para 63. The reference in a letter from Plexus to low cost having been notified on the 15th of May 2014 is in context a reference to the LTS mailbox in resort emails rather than to a communication with low cost itself. So that Plexus email is that Plexus email, but these are the findings of the court.
I don't know where he gets that from at all.
Lady, that is the finding of the court. It's not been challenged.
Telling an intermediary can't possibly be a ground for saying that the person knows it and getting off the hook. And responsible counsel has actually advised that there was no basis of challenging the tour operator's declining cover.
I'm sorry to rise again, but my learned juniors reminded me that this was actually the claimant's case as pleaded. It's page 171, paragraph 30
In the core,
in the core
Supplement.
bundle. Yes,
171.
paragraph 30.
Okay, the way that's presenting it is that the in-resort mailbox is a low-cost
Yes.
mailbox,
Yeah.
not an intermediary.
No, and in
that-
fact,
Is that what is being said?
that may be what's being said, because in fact that might be consistent with, and I'll try and find a reference, the evidence that Mr. Meir gave, that there was an inbox at the resort, and he was from low cost. But certainly, this is the first we'd ever stood. It was an issue that low cost weren't notified, and indeed if they hadn't been notified, there'd have been no reason to sue Irwin Mitchell, because those who took on the case from Irwin Mitchell could have proceeded against the insurers through the Third Party Rights Against Insurers Act. So it's never been a criticism of Irwin Mitchell that they wrongly accepted that there had been notification, or that they were wrong to rely on counsel's advice to that effect.
my lord and my ladies, what I'm going to do is invite you to just perhaps outside of the heat that's being generated by this point at the moment, to reflect, if you will, kindly, by rereading pages 148 and following under the heading whether low-cost insurance policy would have responded to the claimant's claim had it been notified, A, immediately following the initial call, and B, between the 8th of April and 22nd of February. And then you'll see how the learned judge goes through it to reach his conclusion at paragraph 143. Now, I wonder if it's more productive to allow the court to read and reflect on the passages of the judgment, as well as, of course, the paragraph 126, which I've endlessly been referring to. And so we understand the issue to be straightforward in the sense that this is all about ensuring that, or taking your best steps to see that, because I can't actually ensure that the insurer will be notified, because that's a matter between the tour operator and the insurer. But that's the purpose of the advice. The advice isn't just notify the tour operator, brackets, for fun. It's notify, or using a different word, as my lady Justice Falk says, alert the tour operator so that it can notify its insurer in a marketplace in which it is well understood by the defendant that failure to do so can lead to non-coverage. And that's it. Don't need
Can
to.
I ask this? I understand that pre-action protocol, pro formas, and actual letters of claim may well contain warnings, requests, how it may be brought to the defendant in that claim to notify their insurers. Is there any practice or that you can point to that shows that solicitors notify, invite prospective defendants to notify their insurers prior to sending a claim?
Notify the tour operator.
Notify the tour operator.
My lord, forgive me, just give me an opportunity to...
Just as to say, it seems to me it's entirely understandable that when you make a claim, you are putting the insurer, the tour operator on notice of the claim, and it's then essential that they notify their insurers, and that seems to me to be the advice that the solicitor would give. When you notify the claim, you must tell them to notify their insurers. What I'd like to know is there any practice, evidence that solicitors are under a duty to, when they are instructed, to notify the defendants, the proposed tour-based defendants, before they send a claim?
My lord, if you go to the pre-action protocol itself, which is in supplementary, and that's in Authorities Bundle 3,
Yes.
tab 30,
Yes.
page 723, please.
Tab 30,
Page 723, my lord.
yes,
So you're now in the personal injury pre-action protocol,
yes.
which you can see from page 721. And 723 3.1 says letter of notification, and it says in terms, the claimant or his legal representative may wish to notify a defendant and or the insurer as soon as they know a claim is likely to be made, but before they're able to send a detailed letter of claim. And it continues, and I think probably it's best to just invite the court to read to itself, if I may, the remainder of 3.1 to 3.3, and then we won't have to go back to it. So, my lord, your lordship can see, your ladyships, from that it is absolutely referencing the need to have in mind the earliest notification of the defendant stroke its insurer, where A, the defendant has no or limited knowledge of the incident giving rise to the claim, and or B, where you hope they'll actually pay for the claim. And if I can then invite you, please, just back to the judgment. There's another finding that's been made which directly addresses that which your lordship has raised. Starts at page 146 of the core bundle.
Yes.
Paragraph 136. And it's the whole of 136 which goes over to 147 because it's quite long. I invite the court please to read it.
And of course, is in the context of the actual retainer.
Lady, yes, and the actual retainer, there's anything magic in the actual retainer in this case, but this is directly addressing the question from the bench in relation to what was the practice, and the practice is exactly as set out in the pre-action protocol, and the judge finding he would have been inclined to hold that you do, at least with an inexperienced client, need to consider or remind the client to consider whether the proposed defendant was worth powder and shot, and you do this by inviting them or alerting them, or inviting them to alert the tour operator to the claim. If you're on record, you do it yourself, no doubt. If you're not on record, if you're not retained at that point, this is part and parcel of your obligation to protect the claimant from a risk that the learned judge sets out at para 126. Completely understood in the marketplace. Lord, I hope that addresses that issue. It's a very real issue, my lord, and it's so found by the court, just not found pre-retainer. That's the substance of the appeal. Is should it be found pre-retainer? When in circumstances when the defendant has provided legal advice in relation to limitation, the effect of which is to indicate you don't need to take any active steps now. You've got a long time.
I think the point still arises that you wouldn't need to take any active steps now unless the tour operator already knew.
Well, my lady, this is it's a little bit like not going behind the company veil. It's that you can't control what the tour operator does and doesn't do,
No.
but you can alert them, and it's recognised that it's beneficial to do so. And you don't sit and say, but in this case, the insurance was on this basis. It doesn't. It's a recognised problem, and early notification resolves it. See judgment at para 126 and see the way the case proceeded with the, had there been early notification, judge says there would have been, had the claimant alerted the tour operator, no issue of notification would have risen in this case. There was a delay, we say consequent upon a breach of the duty that we're seeking to establish in court today. The consequence of that was there was no % chance of recovering because of late notification.
Well, the reason that notification would have assisted was because it would have is because the insurers were going to take the point that that the tour company was already aware of the incident, so notification would have prompted them to do that which they should have done anyway.
It would have prompted the tour operator to notify the insurer, which had not happened. The state of knowledge of the tour operator, a reference back that paragraph of the judge's finding in the judgment, I think it was 61 of the judgment of taking the court to, which the court would have to do its best with understanding what that finding is, but I understand it as being a finding that it's the intermediary.
I think what I'm struggling with at the moment is the general proposition that a solicitor, whether on a legal helpline or when they are initially instructed on a retainer, as well as considering the limitation period and by when they need to issue their claim, and before that send their
Yes, my lord.
pre-action protocol letters, is that there's a separate matter to that need to consider immediate notification of a claim so as to somehow protect the insurance position. And at the moment, I'm struggling to understand how that arises as a matter of legal logic.
My lord, as a matter of legal logic, it arises because you are looking at the ambit of a duty which is held to exist. And when you open that door and choose to give the advice, you've got a 3-year limitation period. That is a representation. Relax. There's nothing that needs to be done. And the two absolutely run together. So I can embrace the language of reasonably incidental. I can say the defendant needed to advise the claimant in relation to the insurance position as advice reasonably incidental to the advice that it gave on limitation. Now, I've already set out how that's a part of the picture, if you like, but I can put it a different way. I can say the advice on limitation was part of its duty to advise the claimant as to whether she needed to take any steps promptly to protect her position. And see how we put it at para 94 of the...
So
Yes,
you're
my lady.
really saying wrongly gave the impression that there is no rush.
My lady, yes, and see the evidence of mistruck that I took the court to before. This was in the supplementary bundle at 316 to 317. It may just be worth rereading because it may be that the court was in a different place at that time when reading that and was sort of perhaps intrigued, but no more than that as to why I should trouble the court with the section. So at the risk of repetition, may I just invite the court just to have a peek again. So we're in a supplemental bundle at page 316, tab 50, right near the end, which will involve my lord fighting his bundle again.
Page 317.
316, my lady, G over to 317A or B, in fact B. So 316G. Also left with the understanding the position under English law, she had 3 years from date of action to bring a claim. Yes. So nothing to make her aware that there might be something she needed to do urgently. And then we get an answer. I've read it out, so I'm not going to read the next answer because then it was pressed in cross-examination. But so far as what Victoria Halliwell, that's the operator, did, nothing for Mrs. Miller to appreciate that there might, and obviously B is inserted in there, be things that she needed to do urgently. No.
So just to be clear, that the risk that the solicitor has to be considering here is that the tour operator would, by some other route, have been sufficiently on notice to trigger the insurance clause, but didn't notify, but wouldn't then notify if was asked to do so by the claimant,
Well,
putting them on notice of the claim.
That's just one of the routes, because you can have a notification clause that requires early notification, because ordinarily what you'd expect is the defendant knows there's an accident.
Yes, but that's the requirement.
That's exactly the point.
You can't notify something you don't know about.
No, but you can be at fault for not having done so, because you should have a system in place to know if, for instance, there's an accident at work in your workplace, and you just going, "Oh, I didn't know about it because it happened," and so on, doesn't cut the mustard.
Yeah.
And if someone comes late, and your lordship raised the example of pre-limitation, that's part of the joys that solicitors face of taking on cases that they don't know whether it's going to have these problems, and it's for them to choose. I will take your case on a week before limitation expires, or I won't. But it's a very real problem of notification, whether or not the defendant, the underlying defendant, the tour operator in this case, does or doesn't know. It's not just the converting it into this super specific circumstance. It's not like that. If it were like that, we wouldn't be having the judgment saying at 126, this is a recognised problem. We wouldn't be having the pre-action protocol saying it's really good idea to make sure the insurers know, because if that's converted into a sort of in-depth...
Well, I don't think, forgive me, I really don't think that's what that section of the pre-action protocol says. It says you may notify.
Yes, of course it says. Absolutely.
It
It
gives
says exactly what it says.
examples
William.
of situations in which it's prudent to do so,
Correct.
where, for example, they want to get some money out of the defendant early. They
Yes.
might want to make the defendant pay early.
That was indeed one of the
examples.
one of the examples. Well, yes.
It's interesting. The pre-action protocols doesn't say you must always tell the client, even before you start putting pen to paper on a letter of claim, that they must notify the defendant so that they can notify the insurers, because there's a risk that they may not have told the insurers, and the insurers might be able to get off the hook.
Well, my lady, it would be. I think it really is a stand back issue there. We have so many facets of duties of care based upon an assumption of responsibility. For me, not to be in a position to say there's a pre-action protocol which expressly addresses this issue is not.
Forgive me. You're relying on the pre-action process.
I am, my lord, but I'm saying.
Seem to be relying on it rather more for saying something rather more than it did say. Is that? That's all.
Respectfully, I would take issue with that completely. I would say that that's very much looking at it from the wrong end of the telescope. It's as if, unless you've got a pre-action protocol that says there is the very assumption of responsibility that's an issue in this case, it's a weakness for you, not a strength. Absolutely not.
I can see it could be if this was a recognised issue, there could be in a pre-action protocol say the claimant must notify the defendant of the claim as soon as possible.
Well, my lord, we've got
a potential claim.
We've got pretty much that. The claimant or his legal representative may wish to notify a defendant and/or insurer as soon as they know a claim is likely to be made. Yeah. That's pretty close, my lord. That sounds like the same thing to me, and it's exactly what it says.
May wish to, not must. Oh. May wish to.
My lady, I would invite again reflection.
Yeah.
Before
there'll be plenty of reflection. Don't you worry. We're testing out your case.
My lord, there always is.
We're testing out your case to see whether or not.
But the idea that unless a pre-action protocol marries to the nth degree with the legal issue as to whether or not there's an assumption of responsibility in this factual matrix.
Forgive me. Your case is that when somebody phones up this legal helpline or any other similar helpline, that effectively almost anyone with a personal injury claim, potential personal injury, must be told that, as well as the fact that they have a 3-year limitation period, must be told to notify the defendant immediately. And I just, at the moment, can't see where that comes from as a matter of law or sensible practice. And I think, and you're pointing us to the pre-action protocol. You point to section paragraph 136 of the judge's judgment, which again I don't think quite goes as far as you put it. And I suppose what I'm looking for is some help, either in authorities or in some form of guidance as to whether it really is a solicitor's duty, whether on a helpline or when retained, to advise the client to notify immediately any claim.
Well, there's quite a lot in that observation, which I'm going to sort of have to take in stages, including, I think, trying to build my case again, because I'm seeking to address these things in stages. Yes. I think given, if the court's concerned that I'm not alive to the concerns of the court can rest assured I am alive to the concerns of the court. Yes. And seeking to address them, but sort of in stages. Yes. One part of that, my lord said, and it advises in relation to limitation, and it is its choice whether to produce a legal helpline. Yes. It is its choice whether in producing a legal helpline, there may be that if it doesn't advise on limitation, someone can or cannot come back.
I think if it's a personal injury helpline and they don't say that it's 3 years, there'd be a pretty powerful case for saying negligent, because we all know that the limitation period for personal injury claims is a lot shorter than it is for other claims. Yes. And so even if you assume that the punter has a general knowledge of 6-year limitation period, if you don't say it's 3 years, you'd expect them to say 3 years. And therefore, you can start from the premise you've got a legal advice helpline in this sphere, particular sphere. You would expect them to say 3 years. Your case is that by saying it's 3 years, they then take on a responsibility to say, and by the way, you must notify the defendant immediately.
Lady, one can say when saying it, but the point of my emphasising the by saying it, because I mean it's an observation from the court as to whether or not a legal duty of care would have been owed to advise an limitation. It's not one that I would expect would be readily conceded by my learned friend. So that in itself would end up being a triable issue on a separate case. It's straightforward for this court to say that's my view, but it's not straightforward for us to establish these things.
No.
But what we do know in this case is that an active representation was made. So if I can sort of frame it in that way, I'm trying to give the accurate factual context, which is critical for the court to decide this issue. And of course, one looks at it and says, well, hold on, is this an issue which, if you're right about this, it means in every case? And part of my answer to that is already to reflect on the fact that we're dealing with a tour operator, and tour operators don't automatically necessarily know, depends on a lot of things, including the relationship between them and a hotel, whether they have an intermediary, how effective the intermediary is, and so forth.
But then do you cut it down to every tour operator case, but not any other, not other cases where there's a different type of defendant?
My lady, my submission in relation to that is a submission that I make every time to the Court of Appeal and above, which is your task is to determine this case, and the court should always be incredibly wary before obiter observations as to what something means, which then sets someone else off relying upon them, and then another court says, well, that's not right, and that's a matter for another day.
Well,
it's not me seeking to...
That's a perfectly fair response. Take that entirely on board. Perfectly fair response. But even within the context of tour operators, we have to consider that the ramifications of a decision in your favour might be to open other arguments. And the timescale is very important in a case like this. So we've got to consider whether, by advising on the limitation period within 4 or 5 days of the accident, a duty of care is extended, but it doesn't arise if Mrs. Miller rang the helpline 4 days before the limitation expired.
Well, my lady, I can understand why, well, of course, the court needs to consider it, but actually it's my invariable experience in practice is nothing is ever as straightforward as it seems. And statements to the effect of, well, this means it covers all things, when actually in the battlefield fighting that point out is never so straightforward. So I try not to go to this must mean, well, it's not for me, it's for the court, but to make a submission on the basis this must mean. I'm not afraid of the ramifications. It's not that issue. It's just that actually it's this factual matrix that's key. That's all I'm really seeking to emphasise. Can I give an example? This may or may not assist the court. But just imagine that there was a limitation of 3 years, but also an obligation well understood to report the matter to the police as soon as reasonably practical. Now, I've not invented that. That's the Criminal Injuries Compensation Scheme, paragraph 22. So just imagine, I understand you may say that's different, but that's not my point at the moment. But just by way of an example, just imagine that the advice given is you've got to... It's clear that there seems to be some sort of third-party criminal conduct engaged, or this is something that would apply, in fact, in personal injury. We just didn't know it, and limitation advice is given. Full stop. That is, if you like, me trying to show the court why it is we say that actually what is happening is advice is being given. Relax. You don't need to take any prompt steps. It's more than... Sorry, my lady.
I think I understand that. I think one of your criminal injuries compensation scheme example, though, would be clearer. There is an obligation to report within a certain period.
I understand that.
Here, the factual matrix is far more complex. You're effectively saying, well, because the relationship between the hotel, the intermediary, the tour operator might not work very well, we really should try to minimise the risk still further. Now
Well,
that's not, it's
Melanie-
not as straightforward as your criminal injuries example, is it? It's
Melanie-
and you might
Sorry,
view it as best practice. You know, it might be in the category of best practice. There's not a straightforward point there. Not a straightforward.
Well, lady, there are two parts to that observation. May I just seek to deal with them in turn?
Yeah.
The first part is, have I chosen a sort of a fortiori example? Well, yes, what I've tried to do is show
I understand.
an example that now allows the court to recognise it should be released from the bounds of the express representation which is made, and whether in the court's mind it thinks reasonably incidental to, or recognises what's my core case, which is this is bigger advice than just limitation. It's an advice you don't need to take any other steps promptly. Once that threshold has been crossed, of course one then turns to the factual matrix in this case, but now at least the court understands that it can and should turn to the factual matrix in the case and not simply say, sorry, you made an express representation limitation and that's that.
I think that point is well understood. I was
I'm very
just
good.
trying to explore
My lady,
the
yes.
additional difficulty that I think
Yes,
I see.
I don't, my lady, choose to describe it as a difficulty. I choose to describe it as just the reality of the factual matrix in this case. But the second point my lady made was along the lines which, again, I would respectfully encourage the court to draw back from, which was this super specific basis on which it said there is a problem. It's not, it doesn't proceed like that, because it can be a case in which simply the defendant needs to provide early notification of an accident. That's the point, and that's all set out, as I say, that's the para 126 in the judgment, saying, you know, this is I mean, it's quite a big paragraph in the context of this issue that the court is raising with me. So forgive me again if I just go back to it again. It's page 141 of the core bundle. I would accept that as part of their general legal knowledge, the defendant would have been fully aware that insurance policies against claims such as that of Mrs. Miller would often contain provisions which allow the insurer to decline to indemnify if the underlying incident were not promptly notified. That's it.
Okay.
Not because of this funny policy, that funny, it covers, it doesn't matter.
You mean you're reading that as meaning promptly following the incident, are you?
Yes, of course.
Or knowledge of the incident.
No. It's the underlying incident is not promptly notified. It's exactly as it says. The underlying incident is the accident, and if it isn't promptly notified to the insurer, there is a risk understood as part of general legal knowledge in this industry that you're not going to, my language, put the insurer on the hook.
Go back to notification. You cannot give notice of that which you do not know. And so inevitably the risk is the one that my lady has described, which is a risk that the insured does know but doesn't promptly notify.
My lady, you can be held for failure to achieve an outcome just because you don't know. It doesn't matter if there's an accident and you don't notify it, brackets because you're lazy or choose not to, or don't or never inform. Doesn't matter. You haven't notified.
Well, in this case, the reason Plexus give for declining cover was that the tour operator did know on the 15th of
My
May.
lord, yes, and I've sought to go through the learned judge's finding in relation to that letter.
And there was
Para 61.
there was expert evidence. I think, or I don't know whether Mr. Mir was an expert or whether he was a factual witness, but he certainly gave evidence in relation to the insurers saying, look, if you've got a good reason for not telling us, then we'll the practice certainly in the insurance policy market was, if there was a good reason for not giving notification sooner, then the insurers would look at it sympathetically. And you can't think of a much better reason than, well, we weren't told about it until last Thursday.
100 of the judgment, page 127 deals with that. Para
Yes, that's all set out in the judgment at paragraph 100, page 127 of the court
Yes.
bundle. And that's in line with your ladyship's recollection that it was instance, not claims.
Yes.
At HCC, I'm 3 lines down, but expect a report of the number of incidents in the month, and low cost would complete such a report at the end of the month. This is all the stuff that didn't happen, and all that needs to take place is if you alert.
It hadn't been notified. For example, the hotel hadn't reported, but it later came in. HCC would assess it. And if they weren't prejudiced and there was an explanation for the day, they'd usually accept the claim.
Maybe yes, because it's the tour operator can control this situation. It's up to it via its contracts, putting a representative in situ, etc. Claimants had an accident in a hotel and reported it to the hotel management, who were engaged, and so it isn't a sort of innocent hotel scenario in that tour operator scenario in that sense. It's a scenario in which they can put in place mechanisms to ensure that accidents are notified to their insurer. But the reality is this does not happen and needs the encouragement of alerting them to do it. And that's a recognised problem. That's why you've got to, so I then come at the pre-action protocol, not from the, my goodness, it's now been converted against me because I haven't had it established, the very duty I seek. I look at it quite the opposite way round, as that is the state recognising the importance of early notification so that insurers are providing coverage. And it's in the most encouraging terms, like any pre-action protocol, unless it comes to issues of following a specific play out of letter and counter letter and so on. It's not put in prescriptive terms, and nor would one expect it to be. But that in no way means that this court can't find the duty of care is owed in relation to this particular factual matrix. In relation to the factual matrix, I was going to make, I think, 4 submissions. The first is that the defendant well understood the question of whether the tour operator had notified its insurer to be an important issue. And first of all, we see that from the pro forma, and you went to the pro forma, or I took you to the pro forma, but I'll just take you to the page because I'll also explain on that page. So we're in supplemental bundle tab 18, page 172. So tab 18, page 172. And it's just above the top hole punch, tour operator details. Have you written complaining to tour operator? If so, was this within 28 days of returning from holiday? Now, just for the avoidance of doubt, you see, the court see how it's written in no. My understanding, but then Fred nodded at the relevant time, is that that was written in after the legal helpline conversation.
Am I right in thinking that that question was asked by the lady from the specialist?
Yes, later.
After.
It was not asked on the 19th, just for the avoidance of any doubt. I'm taking a document, but I'm explaining that no was essentially not in it at the time.
No, but I think it's...
I'm not sure a finding was made as to precisely when it went in, but clearly it did go in. The document was printed out, and I think a date was given at some point. It might be April 16 or some such when it was printed out. And no doubt someone
a vague recollection
wrote on it.
That it was when the specialist team followed up. Yes, I had in mind paragraph 28 of the judgment where the judge records that on the 19th or 20th of May, probably the 20th, Miss
Yes.
Pegg
Yes.
sent a message which asked for any complaint forms you may have completed following the accident and any complaint letters you may have sent to the tour operator and their response.
Yes. The letter itself, my lady, is supplemental bundle, page 187, I think.
Yeah,
That's the. It was in April. It was May 2014.
yeah. Thank you.
And can I also then go to the judgment? This is in relation to the pro forma at page 120, paragraph 78. And it was suggested by Mr. Lloyd, whose evidence did not impress the judge, as you see at the top of page 120, that though those questions were on the pro forma, they really weren't there to be asked. He says, I reject this evidence. The questions were there on the form to be available for use and filled in if used by the operator. There's no evidence to distinguish these questions from any other than the pro forma, and no basis for inferring they were questions not to be asked by the helpline operator. And those questions, I'm going to come to why they're there, but at the moment I'm simply identifying that they're there and considered relevant by the defendant. And we get evidence both from Miss Strutt, but actually it comes into the judgment, so that I can give you the Miss Strutt quote, but it's in the supplemental bundle, tab 50, page 315, but we actually get it translated into the judgment at paragraph 95 of the judgment. So pages 125 to 126. Let's read over the pages to see where you give yourself context. So at the top of para 95, page 125, the judge says questions on a pro forma about the tour representative details and complaints had not been answered in Mrs. Miller's case. Then if you drop down to the bottom, that would mean that neither Miss Halliwell nor later the practice area would know if she complained. The question appeared on the pro forma because the practice area, that's the International Travel Litigation Group, had identified them as important for some purpose. So what I'm doing at the moment is seeking to establish that they're important. It's an important issue. And whilst the question was not mandatory, see the passage I've just read out, the helpline operator would normally be expected to ask this question. After all, it was on the pro forma because it was important information. And if you go to the judgment at paragraph 88, so paragraph 88, page 123, the judge records after that, that's Miss Strutt. Miss Strutt said the operator would work through the pro forma with the caller. And this is the issue on which we invite an adverse inference to be drawn against the defendant, because the defendant elected not to call, in particular, Miss Halliwell or the managing partner of the International Travel Litigation Group.
There's no discussion, is there, about the purpose, what purpose might be regarded as important? Why?
I don't think it was taken beyond the passages that I have or will refer you to, my lady.
But of course, the operator, as she's termed, advisor,
Yes, my lady.
took a contemporaneous note. There was no dispute as to what she noted at the time.
No.
So why on earth bother to call her? She's not going to remember anything from.
It's not what she said.
In one telephone conversation with one potential client in 2014.
No, it's not what she said. It's what she would have said it's set out at page 42 of our skeleton argument, paragraphs 86 to 87, or 85 to 87 strictly. So page 42, please, of the core bundle. And may I just invite the court to scan read 85 to 87, please? Yes, I think in answer to the observation from Lady Justice Falk, I think the point is that Miss Strutt said it's on there for some reason, but it's not my bag. It's the ITLG. So the issue was deflected. It wasn't that it wasn't investigated. It was deflected.
You're suggesting that one of these other people have called as a witness.
Oh yes, no, the managing partner of ITLG for sure, because the ITLG produced the pro forma.
It's the banks.
Yes, they produced the pro forma, and it was important for some reason, and no one was there to tell us why, and that could have been and should have been something that we were entitled to explore. Failing which, their election not to call that person invites an adverse inference to be drawn. That's what we're saying.
But the judge didn't do so.
No.
The judge did not
So
do so.
how can we go behind that?
In the same way that one can make an appeal based on a failure to draw an adverse inference any time. I mean,
Where's that in your grounds?
it's certainly in the skeleton argument, because I've sort of
Where is it in your grounds?
I understand, my lady, and it's not expressed as its own individual grounds. That much is apparent. Page 15 in no way breaks matters down in that way. This is a case in which permission was given generally, if I can put it that way, by the learned judge. And so what then happens is you then draft grounds after you've got permission, which is always an oddity, because it could be that someone puts in grounds which overextend from that which permission was intended to be granted for, and so forth. And then it can lead to effectively a sort of combination document by way of grounds and skeleton argument being produced, which between them set out the force of the claimant's case, on which my learned friends never said, well, we never understood it. They've responded to it.
I'm a little surprised. This is not intended as a criticism at all. But I'm a little surprised that when you're asking the judge himself to grant permission to appeal, you don't formulate your grounds first. Certainly when I was in practice at the bar, you did.
Well, lady, I've given advice to a similar effect in a number of cases in which I've been involved in appeals, and I'm fascinated as to how. The question is, someone says, "I just want permission to appeal." I say, "Well, what on?" tell me.
It's a little surprising, isn't it?
You know, because I'd like to know, and I'd like to see.
As I say, it's not a criticism.
It's a commonplace, or at least if not a commonplace, it's something that I've personally witnessed.
Well, maybe that's something we ought to say something about, because it's not very desirable.
No, my lady.
It's not really fair on the judge either, in a way,
No,
because the judge has got to actually realise on what basis you are criticising him or her for coming to the conclusion that they do.
There you go. But what happened is permission to appeal for the record is given. It's set out at page 81 of the core bundle. The ladyship's already alive to that. That's there. My second submission in relation to the factual matrix is the question was important because early notification of the accident to the tour operator, or I'd probably change that notification to stubble notification, early alerting of the accident to the tour operator should lead to early notification of its insurer, and so the insurer responding to the claim. And here I was going to reference, first of all, the judgment at paragraph 126. And I think that might trespass on your goodwill, were I to do so without reason, by way of seeking to respond to any further observation as opposed to when making my submission. So then I go to that, which included the words which allow the insurer to decline to indemnify if the underlying incident were not promptly notified. And that's why answering questions about what would have happened if the client had come 2.5 years after the accident is an interesting but different case. And I simply, a question of ducking these things, I just think it's a different factual matrix. No doubt the claimant would argue one way and the defendant the other. But it's not this matrix. The question was in the pro forma precisely because the defendant understood the importance of the tour operator providing early notification to its insurer. And the terms of the letter of claim when drafted are relevant for these purposes to understand that they're in the supplemental bundle. That's page 205, tab 35. And if the court will kindly turn that up, so it's tab 35 of the supplemental bundle, page 205. And the court will see that the first substantive paragraph after simply identifying that the accident occurred on a given date is this paragraph. Right at the outset, in other words. Please confirm the identity of your insurers. Please note your insurers will need to see this letter as soon as possible, and it may affect your insurance cover and or the conduct of any subsequent legal proceedings if you do not send this letter to them. For this reason, a copy of the letter is attached for you to send to your insurers. Please do so immediately. And again, it can be said, well, that's a letter of claim, but of course we're dealing with something different. But the point is, this is well understood by the defendant to be a point of real significance. And as soon as it fires off its letter of claim, it's front and centre.
Well, we know, don't we, that in the existing, this policy, there was a separate requirement of notification after a claim.
Then I was going to refer the court to the pre-action protocol, but obviously I've done that, my lord, so I won't. So this is part and parcel of this part of my submission.
But I don't think you've met any resistance from any quarter to the fact that when you make a claim, a formal claim against a tour operator, it is essential to advise them to send that claim onto their insurers. I don't think there can be any doubt about that.
Well, we keep coming back to
the question in this case is whether sometime before, when somebody rings a legal helpline,
yes, my lord,
whether or not there was a duty to inform them to notify the tour operator immediately.
Absolutely,
afterwards.
my lord. But what?
It's a completely different question, isn't it?
My lord, different question, but actually relating to the same issue, and so not completely different, but providing highly relevant factual context for the assessment as well as assumption plausibility, because the same problem ensues at the earlier point, all the more so.
You're referring us to this because you say it's evidence that the problem was known without there, and the defendants knew about it.
Absolutely, and see the judgment of paragraph 126, which says all of this. Absolutely. Thirdly, the context for the legal helpline telephone conversation was that the defendant had represented that the claimant should call to see how we can help you. And there is the video. I don't know if the court has had the opportunity to click on the hyperlink, but can I invite the court, if not to do so? It's incredibly short, so it really won't take much time. If you go to supplemental bundle, obviously electronic. If you go to the electronic supplemental bundle, page 164, you click on the hyperlink, and I guess it's 30 seconds or thereabouts, something really short. And what is said is at the end of the advert, is the voiceover, is call us to see how we can help you. What the learned judge respectfully does is he mischaracterizes that as if we can help you. See, and it's important. See first of all, page 97. So paragraph 19 at the top of page 97. The advertisement to which Mrs. Miller responded was played in court. Effectively, it was an invitation to ring the helpline to see if the defendant could help. But it wasn't. It was an invitation to see how they could help.
Well, up to a point. I mean, supposing they couldn't help because the accident had occurred 3 years and 5 days earlier.
Absolutely, but they could, because they gave legal advice. They could help. Phone us up to see how we can help you. We're now going to help you. We're going to give you legal advice establishing a duty of care in relation to the limitation period. We are giving you that as legal advice under the assumption of responsibility. See the observations of the court today that even if they hadn't given it, they would or may well have been held to such a legal duty. So they were helping. That's the point. It was a legal helpline that was helping. Whereas the learned judge, when he comes to his absolutely core assessment, so he repeats this for the avoidance of doubt at paragraph 61 on page 114, says the same thing in relation to the advert. And then when he comes down to his core assessment, it is in relation to the assumption of responsibility, which starts at page 136 right at the bottom under the heading A Tortious Duty of Care, goes through case law, etc. And I'm just going to pass it on that for the moment. And then when you get to para 119, you get a way of putting the case which is not exactly aligned with this. Then you get 120, I don't accept this, and then you get 121, in which he essentially draws the threads together. And he says the facts upon which the claim particularised do not actually support her case. I do not accept the defendant held itself out via its TV advertisement as ready, willing and able to assist persons in the position of the claimant. Ready and able in principle, yes, but its willingness depended on a sifting process and the creation of the retainer, and its advertisement did not say otherwise. This is essential to the judge's reasoning, and that's because he sees that the advert's just saying, we'll see if we can help you. Give me some information and I'll take it away. And someone will contact you. It's a sifting process, that's it. You haven't had an accident 3 years and four days afterwards, or as I say, thank you, but I don't want your case.
Well,
you haven't had one where you've recovered in 4 weeks. I'll say, thank you, I don't want anything to do with it.
Well, let's be fair to the judge. If you carry on reading paragraph 121,
Yes, ma'am.
he goes on and says that Miss Halliwell did give some limited, high-level and generic legal advice, but she did not purport and couldn't have been understood to be complete or comprehensive legal advice about her claim.
Absolutely.
So he accepts that there's legal advice. It's a legal advice helpline. What he's negating there is a suggestion that it's the advice concomitant with the sort of advice that you'd give under a retainer.
My lady, I've already, again, that comes in parts. What we've got is, it's difficult to read this, and as this is the judge accepting there is a legal duty of care based on assumption of responsibility in relation to limitation. That's not how I've read it. If that's what he said, then that's not an issue for me. I don't have to even prove that step or by way of submission or establish that step. But what he's going back to is limited, high level, and generic. And I've made my submissions in relation to that. That is a downgrade. That is a downgrade of the reality of that which happened, which is there was an assumption of responsibility by the defendant on any view when they advised this claimant that her limitation period was 3 years, because that's in substance what happens. See the references I've given earlier on in relation to that. And then we start to see this in a completely different context, completely different from the way in which the judge has approached matters, because the judge is still stuck with, you can just throw out a little bit of high-level legal advice, but essentially you're engaged in a sifting process to see if later we can help you.
Okay, so you say he made an error in saying, or appearing to say at least, that there was no assumption of responsibility.
Yes,
at all.
madam. That's what I've understood by ground one.
Right.
I've understood ground one to
Yes.
be
Okay.
the judge didn't accept any legal duty. That's why I've taken you through that stepwise. That's my understanding.
Mm.
He didn't accept that.
So what do you make of Mrs. Miller was certainly entitled to rely on such advice as she was given then, if that's not an assumption of
Oh,
responsibility?
I know, my lady. Of course I rely on that. I took your ladyship to it
I
when,
know,
when
but-
seeking to establish that there was obviously an assumption of responsibility
Yeah,
in
but
relation
how do you
to
square that
limitation.
finding by the judge with your submission that he's found that there's no assumption of responsibility?
Because, my lady, he doesn't say there was a legal duty of care owed in relation to limitation. I mean, it's just not there. It's, what you
Leave
get.
leave out the limitation bit for a minute, because I know you're hinging your whole submissions on the limitation point. But surely, on any sensible reading of that paragraph, the judge is saying there is a duty of care, because there's no contractual relationship at this stage. He's not found any retainer. She is entitled to rely on such advice as she was given. That must mean that there is a tortious relationship.
Lady, in one sense, if
All he doesn't
sorry.
say is it emanates from the limitation argument, or the advice that was given about limitation.
In one sense, I don't need to make any submissions in response, in the sense that if the court is reading the judgment, so to say, the court's reading the judgment, so to say, it's not how I've read it. I've made that submission because I would expect a judge to say, in terms, I accept that there is a legal duty of care in relation to the advice that was given on limitation. Instead, it's framed in high-level and generic legal advice about personal injury claims. And then he adds in the reliance, and that's why it's inconsistent. And it's so obvious that there was reliance and that the defendant reasonably would have understood. And I've gone through all of that. Those are my ground one submissions. So, my lady, I can't really improve upon that. I'm just trying to be fair also to the judge, but to understand what it is he has done, what it is he hasn't done. My own friend in his skeleton argument, I think it's para 28 or thereabouts, says, "Oh, we don't accept that." But even my own friend doesn't say, "We accept in terms that there was a legal duty of care."
Well, we'll see what he says in due
Indeed,
course
but
about
we
that.
haven't. It's not put out nice and express, crystal clear. This is what we accept was the common law duty that was owed.
Anyway, you say that he should have said, well, there was an assumption of responsibility emanating from the fact that advice was given on the limitation period.
Yes, my lady, and this would well,
Not from the fact that legal advice was given full stop.
both, my lady, if you
yes.
like. If
In a
you
way,
like,
you
but
said
it's,
just,
sorry, my
just
lady.
as in Crossan, it's you started to say something about costs, so you needed to go on. This is effectively you started to say something about timing, so you needed to go on.
That's
That's the
That's our
equivalent,
case,
isn't
my
it?
lady. Yeah,
No.
absolutely.
Understood.
Absolutely. You can reject it, you can accept it, but that's the case. At least you'll understand that's.
I think we've understood that at about 11 a.m.
Oh,
Yes,
I didn't mean it
But-
in that. I didn't mean it in that way. Only that the sense that sometimes is certain
I think when you
difficulty
took us
on
to
my part.
Crossan, I think we understood that. So how are we getting on?
We're doing well. I mean, there have been a number of extremely helpful observations from the
Yes,
court.
we've been testing the breadth and scope of your argument.
But it's soon going to be repetitive I wasn't going to so much draw the threads together and say where the judge has gone wrong, because I took the view that by the time I'd gone through all of this, you could see the case. I didn't need to sort of do it that way. So it's actually pretty short in relation to finishing this off, because as submitted and as the court observed, the court has the way in which we put the case.
I think it's fair to say the judge does a detailed analysis of assumption responsibility, but his conclusions at the end in paragraph 121 are perhaps not as crystal clear as they might have been. I think that's a fair point.
That's
but
the reality.
But the key finding, which I think you are plainly challenging, is he says that that the facts to which I've referred did not give a rise to a duty on the defendant to provide such advice, and that advice is in relation to ensuring the insurers were informed.
Absolutely, he finds against us for sure. Absolutely.
Whether or not he has said there was no assumption of responsibility, I agree with Milady, given it's a little bit difficult given his immediately preceding words.
It's untenable.
But I don't think he hasn't said it.
But
So
he
I'm not
hasn't
sure.
gone and said that he's recognised that there's a legal duty. Anyway, my lord, I can't really improve upon that, because that's what happens. It's there as a judge. So like looking at a contract that's imperfectly drafted, you know you're stuck with going round.
So have we done 1 and 2?
Oh, well, we're just finishing off 2, because that's the best way. So
Yes.
I really won't be long after lunch with 2, because it will become repetitive, and then I will be able to deal in fairly short order. I think I can, with the access point. I'm going to make my point shortly, because this will be sort of very much terra firma for this court as well. So
yes,
more so than.
So you're going to say a bit more about ground 2 after lunch.
A little bit more, my lord.
Very well.
And although it's 3 minutes to 1, this is a convenient place.
No,
I've got a fourth.
It is. I wasn't meaning to stop you. I thought you were drawing it to a conclusion, and I was wrong.
That I have that look about me, my lord.
And if you want to carry on for the last 3 minutes, by all means do. Yeah.
But then, my lord, I was going to finish off that the advert saying how we can help you implies the defendant will actually help the claimant, not may help the customer. Or put a different way, a reasonable person in the position of the claimant would not have understood that the purpose of the call was only to sift her claim.
Is another way of putting it that they didn't sift it out, as in they didn't reject.
My lady, it's a part of what happened is they didn't reject. So it's but even if they'd rejected, you end up in a little bit of a position like Crossley. You can say, well, I'm not going to take a case on. But if you leave a person hanging, it's the same problem.
Yeah.
That's our case. That's what it's about. You're leaving them hanging, completely unaware that if they only alerted the tour operator, which is not difficult, they would prevent a world of pain from ensuing, which was absolutely front and centre for the defendant.
Well, we do have to remember here that this phone call wasn't the be-all and end-all of it, because of course there was a follow-up call on the 20th, and a whole series of follow-up calls. So I'm not sure whether one can assess the defendant's response in just simply one phone call, because of course the content of how can we help, to see how we can help, may well suggest how we can help going forward. It doesn't just mean solely and exclusively in the course of this phone call.
And of course, the Miss Pegg, when she did put pen to paper on the 20th, which is not that long after, day after, specifically asked questions that might properly have been asked on the phone call because of the checklist. You've seen it, but she did ask for details of any correspondence with the tour operator.
Yes.
And there was no response to that.
No, my lady. But that rather makes my point. First of all, you don't judge the duty of care with the benefit of hindsight. So I'm not saying the court needs to sort of blinker itself to the sort of, for me, inconvenient facts that the claimant didn't come back in any way promptly to the further invitations. But actually, the existence or non-existence of the duty of care is determined by the matters that take place on the 19th. See the case law to which I've referenced already. It is determined by the interactions, the matters going between the two parties on the 19th. And if the court recognises, as per the raised issue by my lady Justice Andrews, that actually what was asked on 20th should have been asked on 19th, and we would have established that, we'd had a witness to cross-examine in relation to that step should then have been taken. That's precisely our case. So of course, the legal helpline isn't the panacea to all ills. It's not going to resolve everything. The underlying issues in relation to the merits of the claim, local standards as to whether the staircase was defective and the absence of a stairwell was going all the way down is something that was a local breach of standards, etc. But what they did do is exactly the issue that the court has, see the observation by Justice Falk, in relation to, you told me that it was okay not to do anything at that point because you told me limitation is 3 years away. So that's I do not in any way see as inconsistent with our case. My Lord, if that's a convenient moment.
We'll resume at 2 o'clock. I'm really struggling on my supplemental bundle.
My Lord, yes. Can we seek to sort that out? If you, I mean, we would.
You can. Otherwise, I'll download it and do it electronically.
I'm afraid I've got exactly the same problem, but
And what I do is suggest that someone brings two. We don't really want to touch your files.
No.
Yes. So I think more a case of passing up. We can hand up 2 folders before 2 o'clock, whenever the court's open. So
Yes.
we can put
that would be very
give them
kind.
to
If you
your
can, and our
clerk,
carts can fix it
and
before
then-
we start.
and perhaps invite the court to see how it then collects them and uses them,
Yes.
rather than having to do it manually at
Really
2.
sorry to put your solicitors to the trouble,
No,
but
we'll
these
just
bundles
grab
can
a
have
couple from Chambers.
a habit of
They do.
collapsing.
See the observations of Lord Justice Sedley, as I recall.
On that note, 2 o'clock.